Good afternoon to all the members who joined today's session, another session of learning under the aegis of EEE webinar series, Master Knowledge series. And today we are going to discuss a very, very important and an interesting topic at the same time, intellectual property rights. Intellectual property rights and trademarks plays a crucial role in protecting and commercializing ideas, brands. Both IPR and trademark are fundamental components in the protection and management of creative and business assets. IPR encompasses various forms of legal protections for creation of the mind, including patents, copyrights, trademarks, and trade secrets. And in particular, trademarks safeguards the distinctive sign, symbol, or name that identify the distinguished goods or services in the marketplace. By securing these rights, business and individuals can protect their innovations from unauthorized use, establish brand identity, and maintain competitive advantage. Effective management of IPR and trademark involves understanding the scope, navigating registration process, and actively enforcing the renewing protections. Grasping and overseeing the IPR and trademark is essential for protecting the innovations and upholding the brand integrity. By adhering to the proper procedures and remaining vigilant, individuals can safeguard their intellectual assets and utilize them for business success. To address this critical aspects of safeguarding IP rights, our member plays a key role. And today's session, titled as Intellectual Property Rights and Trademark from Concept to Protection, aims to provide valuable updates and insight into this important field. So today, to deliberate on this important topic, we have with us C.S. Nayan Rawal. He's an advocate, patent and a trademark attorney, and it will be my proud privilege to read his brief profile in front of our all learned members. He's a qualified company secretary with more than 2.5 decades of extensive experience in the corporate law, compliances, and specialization in intellectual property rights. From being denied a specialization in intellectual property rights during his law graduation to become the India's first IP coach and witnessing the changing contours of IP laws in India, along with being a part of this transaction, his rich experience as a corporate lawyer, and he has developed various practices areas such as corporate law, FEMA, related matters, mergers and acquisitions, and public relation management. He has hands-on experience in handling consumer protection matters for products of pharma clients, drafting franchise agreements, and IP commercialization matter. It's our proud privilege to have him as a speaker for today's session and get benefited from his words of wisdom in the arena of intellectual property rights. And with this, we welcome him at the 14th session of EEE Master Knowledge series, and we hope to have a very enthusiastic learning on this topic. Members, friends, I would like to remind you that applications for ICSI and National Awards for Excellence in Corporate Governance have been opened for the year 2024. We solicit your applications under the 24th ICSI National Awards for Excellence in Corporate Governance, 9th ICSI CSR Excellence Awards, 3rd ICSI BRSR Awards, and ICSI Lifetime Achievement Award. The last date to apply in all the categories is 14th August. And for further information, please visit the website of ICSR. And with these words, I hand over the session to our learned speaker, C.S. Nayan Rawal.
Thank you so much, Surabhi, and a very pleasant good afternoon to all of you. Are you able to hear me, all of you?
Huh? Yes, sir.
Yeah. So before we start this session, let me would like to interact with whatever participants are there. So what is that they want to know about intellectual property? Can we have something on a chat box or whatever way we can communicate, whatever the system is to communicate? What is that they want to know about intellectual property? So when they have come here, they must be having some kind of objective that what is there in me, what is there in this for me, and that me I want to know from the participants if they can communicate through you. What is that they are looking out for?
So one of the participant is posted in the Q&A boxes. They want to have a highlight on how to appear before registrar trademark in
Uh-huh.
case of litigation.
Okay. No, litigation is something we'll only dealt in High Court, but yeah, there are some kind of litigation which are done in before the trademark tribunal also. Of course, I'll help you out for that.
Some other targets which our members are having with this session is application under the trademarks and about the practice areas within the IPR.
Yeah. No, there is a complete
Scope
yeah.
of CS in IP Act.
Yes. So there's
infringement.
Okay.
Registration of trademark.
Yes, very good, very good.
Leveraging of IP.
Yeah, that is something very interesting. I am really happy that such question is also being asked. Yes, anything else?
Understanding the filing patent applications is specifically for technical companies.
Okay, so fintech companies are kind of, to be very frank, precise, today AI has become a buzzword in everywhere. So how do you file AI applications, correct?
Yeah, right. How to deal with the opposed application.
Yeah, very good, very good, very good. Thanks, thanks for a lot. Little bit, always there is a very obvious thing that I have been experienced in the last 2.5 decades is that when you start a journey, you should know where is the destination. Otherwise, you will go anywhere. Since I'm staying in Mumbai, if I have to go to Churchgate, I know I should go to Churchgate. Yeah. Why do we require? The question is, why should we learn IPR? Yeah. Now, these are some micro level questions which have been asked to me. At macro level, I would like to ask people, why should we learn IPR today? Because it has become a buzzword since last only 10 years. I wanted to learn this in 1991 when I was in my third year LLB and I was denied this subject. That you will not be allowed this subject because there were no teachers. There was no material also in those days. So I was denied these subjects. And today now we are talking about only an IPR. So why should we learn IPR? First of all, that's what the first question I would like to ask myself also and the August audience. Why should we learn IPR? Why this has become all of a sudden so much of importance? Can anybody answer this? Has anybody answered it?
Not yet, sir.
Okay. So try and understand my question. Why should we learn IPR? Its practice is there, fine. But why all of a sudden this has become important since last, say, 10? We were not talking about IPR 10, 15 years back. I'm learning this subject since 1999. Let me tell you very frankly. And I was never invited till 2005 for all the 6. It was only
one of the member given the answer for the purpose of recognition. We should learn IPR to protect the brand, protect our intelligence, brand value, awareness.
Awareness, yes. IP awareness is very less in this country. Let me tell you very frankly. It's absolutely very, very less. In IP awareness is one of the most important thing. That is fine, but why all of a sudden this has become important? Last 15 years, nobody was talking about IPR before 15, 20 years.
To have awareness and protection of our trademark and not to infringe another trademark.
So that's again a micro level question. I am still asking at a macro level.
As an important asset in the modern day business.
Yes, it is an important asset. Yes. Now, little bit this person is near to what I want to explain about IPR. Now, tell me one thing, one more question, and that will make this point very clear. Who is the richest person in this world? Or which is the richest company in this world? Who's the richest person or richest owner of a company? Who's the richest person and the owner of a company? According to you, who is the richest person in this world today? A few names may come out. Yes?
Yes, sir. I'm also waiting for the names to come and.
Yeah.
Who's Elon Musk, one of the.
Yes, Elon Musk. Yes, it's very correct. One of the richest person is Elon Musk. Anybody else? It is not only the richest person. There are so many other richest person. I'm not saying the most richest person. Who are the richest person in this world?
And the company is Tesla, Elon
And
Musk.
Tesla and Elon Musk. You can even say Jeff Bezos and Amazon. You can even say Microsoft. Yeah. But question is why they are rich. Are they rich because of the shareholders' value? Are they rich because of the fixed assets they are owning? Are they rich because they are having businesses all over the world? It's the IP which has made these people richest. Yeah. If you value this company, the valuation may be more on the ideas, technology, and innovations which has made this company what they are today. So the backbone of the success of this richest people is actually an intellectual property. And that is why we are required to be here. And that is why the institute insists on you to understand and really absolutely become a good professional and integral part of the corporate world where intellectual property is going to be the most important thing. Yeah. Now, being a company secretary, you are all company secretaries. Yeah. And you're all dealing with annual reports. Have you anybody seen the annual report of Reliance for last 3-4 years? Has anybody seen the annual report of Reliance for last 3-4 years? Yeah. If they have seen the annual report of Reliance, they do mention the trademarks which that company is owning. Now, is it required from any point of view of Companies Act or LODR or any other requirement, corporate governance requirement or anything in India which make them disclose what are the trademarks that they are owning it? Is it required as per the Companies Act or LODR or any other law in this Companies Act? I still read annual reports. I wish to attend the AGMs also. I used to attend AGMs when I was a budding company secretary and I have learned a lot from them. Yeah. So did you actually ever notice that why there are number of brands which Reliance is owning? 140 to 150 brands list is given in their annual report. Why that is done? Why that is done? Is it required as per LODR? Is it required as per Companies Act?
Sir, members have given their answer as yes, it is required.
Where it is, which provision of the LODR requires this? Or which provision of the Companies Act requires you to disclose the intellectual property you are owning? Yes. Specifically, which provision requires you to do this? Yeah, you're all company secretaries, correct? So which provision requires you to do this? There's no provision in LODR in Companies Act to disclose intangibles. I am not covered. Or even reporting guidelines of Institute of Chartered Accountants or any accounting standards don't require them to report intellectual property. Yeah, we are supposed to be the most important part for the reporting purpose. Yeah, we report related party transactions, we report board meeting, company secretaries, that secretarial audit report, then corporate governance report, and so many BRSR reporting. Huh? But anywhere there is required that IPR has to be reported, say yes or no at least. Show me the.
Sir, some of are saying yes, some of the members are saying no.
But they are not sure about it. That means
yes.
Yeah. So that means there is no specific provision. Yeah. But then why did Reliance did that? The question is Reliance was the first listed company on New York Stock Exchange. And the corporate governance code of the US required them to disclose the intangibles. So internationally, the value of an organization is based on how much it owns intangibles and not on how much it owns fixed assets or how much its shareholders' value is. The shareholder value is determined by intangibles and that intangibles creating the products and the business that they have done through these intangibles. That's what the reporting of intangible and intellectual property. Now, this is one of the most crucial role a company secretary can play in understanding an organization, the understanding the innovation process, the understanding of intellectual property. Yeah. So with this background, I would like to go in. How do I share it? Can I go to the share screen?
Yes, sir.
Yeah. Is everybody able to see my screen?
Yes, sir. You can have it on the slideshare mode.
Yeah. I think so. This will I'll do this.
Yes.
Are you able to see everybody?
Yes.
So what I am trying to do is this, by end of this session, you will be able to understand the concept of intellectual property, explain the purpose of intellectual property, economic aspects of the intellectual property, and associated with the need for intellectual property in the cyber world or the today's digital economy, what you say, interpret the national and international perspectives on the need for intellectual property, and list the types of intellectual property. It's not only the registrable intellectual property. There are so many intellectual property which may not be having an requirement for registration, but still they are the most intellectual property. Like one of the data of your company, database of your company is one of the most strong intellectual property in today's world. Data is going to become the oil of the next digital economy. Yeah, it's the most important oil of the digital economy. So that also is an actually recognized intellectual property. Yeah. So what is intellectual property? Resulting from intellectual activity in industrial, scientific, artistic, and literary field. Any activity which is creating an industrial purpose, a scientific purpose, an artistic purpose, or even a literary field. Yeah. Recognition gives a cluster of recognized rights associated with innovation and creativity. It is the innovation and creativity which creates intellectual property. Yeah. And it's more of a mental as against physical products. Example, land or other intangible assets. In 2000, there were some Fortune 500 companies which were valued. And those Fortune 500 companies do existed in somewhere in 1990 also, 10 years before 2000. Both the companies were valued. Now the difference was that in 1990, their valuation was based on the fixed assets that they had. And in 2000, it was on intangible assets they had. So that's what the difference is all about. So it's intangible which is working all over the world today. Yeah. Now this person is somebody who has taught me intellectual property for the last 25 years. He is the source of inspiration for me to specialize in intellectual property because he gave me a beautiful sentence called that imagination is more important than knowledge. If you have imagination, then only that knowledge is able. Everybody has knowledge. Everybody has knowledge. Everybody has information. But when you apply imagination to this knowledge or information or whatever unique thing you create an idea. And if you manifest that idea, it creates intellectual property. So try to understand this equation. Everybody has knowledge. When you apply imagination, it creates an idea. That idea is manifested in some form or other. It has to manifest in some form or other. When you manifest that, means you are expressing that idea in some form. The most underlying principle for creating any intellectual property that there has to be an idea and it has to be in express form. If it is in a notional form, nobody will recognize that as an intangible or intellectual property. That's the most important thing, that imagination is more important than knowledge. Yeah. So this is what all about intellectual property deals with. It deals with ideas. It deals with technology. It may be an invention. It may be any artwork. It may be a music or literary work. Yeah. It could be anything. Yeah. Today, the Indian companies are actually getting awards in USA. Yeah. The Indian music is getting awards in USA. It was not happening 10 years or 15 years back. That's what the power of intellectual property is all about. Yeah. Artwork. Yeah. So many sculptures are important. In fact, I'll tell you, the first trademark was born all over the world 3000 years ago in India. I'll tell you the story when we come to the trademark. When we come to the trademark section, I'll tell you this story, how this has happened. In fact, the whole intellectual property concept is given by India to the whole world. The whole world is nurturing and now giving back to you. It is we who created the concept of intellectual property in this country or in this world. Yeah? Yeah. So IP is intangible when created, but become a valuable intangible form as product. So as I said, then when you have an idea and when you express or manifest it in a particular form, it become product. It may become product or it may become any kind of services. It may become any kind of useful thing. Yeah, that is meant to create an economic value. And when it creates an economic value, that's where the leveraging of intellectual property happens. Somebody asked me, how do you leverage it? Yes, we will come to it. I have case studies also as to how we leverage IPR also about it. Yeah. So intellectual property has two factions. One is industrial property and one is copyrights and related rights. One is industrial property. Now, industrial property has certain branches, and that if you are having an invention, it qualifies for you to get a patent on it. If you have an configuration or a pattern or an artistic creation, it qualifies for you to get a design registration. If you have a brand, it qualifies for you to get a trademark. There are certain products which have certain characteristics and features which are associated with that particular geographical region. They are called appellations of origins. Means those characteristics and features are only found in that particular area only or in that particular geographical region. That qualifies for a geographical indication. The best example for this is Darjeeling tea. Yeah, you cannot grow and cultivate Darjeeling tea in Delhi. You cannot grow and cultivate Darjeeling tea in Mumbai. It will not taste the same thing. But what you cultivate in Darjeeling tea will have the same taste. And that is what is also recognized as intellectual property in the form of geographical indications. Then there are trade secrets. Yeah. Tell me which is the biggest corporate trade secret in this world? Yeah. Which is the biggest corporate trade secret? Is anybody able to tell me what is the biggest corporate trade secret in this world? Yeah. Anybody? Which is the biggest corporate trade secret? Universal corporate trade secret. It's a corporate trade secret. Only the 7 board of directors of that organization knows what it is. Rest of nobody knows it.
So one of the answer is Coca-Cola.
Yes, exactly. Very good. The formula of Coca-Cola. It is not patented. It is still a trade secret for more than 100 years. And how they have managed to make product out of it, that's absolutely the business method. That is the most innovative business method in the world that they created. Coca-Cola does not manufacture anything for itself. It's only markets. And the Coca-Cola has only 2 important intellectual property: the shape of the bottle and the brand. And that is valued every 1 decade. And that value goes in billions of dollars. Billions of dollars. In I think in 2015, yeah, that's what the last valuation I have heard about it. Only US business of Coca-Cola was valued and it came to more than $80 billion. $80 billion, out of which 90% was attributed to the intellectual property in the form of brand and shape of the good. Only 2 intellectual property, and see the kind of value it has created for itself. That is why intellectual property is most important. Last is integrated circuit. This is becoming more and more popular since last 2 to 3 years. Integrated circuits are nothing but semiconductor chips. They are topographies or designs for chips. These chips do the wonder thing. It is very helpful in lot of business like automations, automobile, healthcare. It has application in various industries. They are the topographies of circuits which are creating. Like it's a best thing I'll tell you. The smartphones, before 2009, there were no smartphones. Smartphones came only in 2008 and 2009. Smartphones does the work of computer. Smartphone does the work of even your bank. Smartphone does the work of even your, say, photography. Yeah. But except communication, it does everything. That's the only problem in India. That except communication, which is their main function, it does because we have a network issue everywhere in the world. Yeah. So that is all possible because we have something like semiconductor chips. Different kinds of chips are designed. These chips are very, very important. They have a configuration in the form of a topography, and that topography is protected as intellectual property. So this is one of the most important slides which will explain what exactly is intellectual property. Then we have copyrights and related rights. The copyright subsists in a work. The work means it's a work. It could be a literary work. It could be a dramatic work. It could be an artistic work. It could be a musical work. It could be a cinematographic film. Rights related to performers, broadcasters, and sound recorders. So last right is also called as neighboring right or related rights. The neighboring right or related rights of copyright. That is why the title is copyrights and related rights. See, copyright is basically in a work, and those work are literally dramatic, artistic and musical work and cinematographic film, and the related right. I'll come to each one. Literary work exists in form of anything which you have written, even a manual of an instruction manual of a product, like how to use mobile, how to operate computer, how to use any gadget which has an absolutely instruction manual, that also qualifies as literary work. The softwares and the programs which are written, they are also classified as a literary work. One of the best case study I can give on literary work is about Harry Potter. Yeah, and this is the most neglected intellectual property of this country. In India, this is most neglected. I'll tell you how. Yeah, everybody has read Harry Potter. How many series? How many series of Harry Potter? सुरभि जी आपको पता है?
Sir, 7.
8. In
Eight.
July, I think so, 2020 or 17, sorry, 19, I think so. 8th series was also launched. Yeah, 8 series of intellectual property in the form of a literary work. Now, I'll tell you the story of this lady. Who's the author of Harry Potter? J.K. Rowling. Yeah. Now, that lady was a divorcee. She was divorced by her husband. And when she was divorced, she didn't get much of the kind of a benefit in terms of money value or economic value to survive herself and her son. They both were alone and were deserted by her husband when she divorced. But she had a flair for writing since childhood. So she started writing small articles in various editorials. And that started getting her attention. So then people insisted that why don't you write something good? And she wrote the first book of Harry Potter. And rest is history. You know why that word is known, that title is known as Harry Potter? Harry is her son's name. And what is she created the world wealth out of that one literary work? What is she created? Today she is hiring more than hundreds of lawyers all over the world to protect her licensing rights, because Harry Potter is translated in 15 foreign languages. 15 different foreign languages. And that is what has created wonder for herself. Yeah. And one literary, no, she has written only in English language. How many languages we have in our country? We could not produce one single Harry Potter. That's why I said that this is most neglected intellectual property. The commercialization and the leveraging of IP is something, a big issue worldwide. It's not only India, worldwide. Yeah, it's a big issue, because how to do it? Because there are people only involved in IPR is only lawyers. I think IPR should be taught to everyone. It should be taught to technical person. It should be taught to management graduates. It should be taught to legal people. It should be taught to even company secretaries. It should be taught to even chartered accountants. The reporting and valuation of IPR is the biggest issue in this world. Yeah, every 1 decade, Coca-Cola gets valued. Now, who does that valuation? And how does it know if it does not know what is intellectual property? So that's what it is. Then we have dramatic work, artistic work, music, and rights related to performers and broadcasters and sound recorders. Can Lata Mangeshkar claim copyright in her song? Of course, she's now no more. But when she was alive, could she claim copyright in song, that it is my song? Tell me. Can she claim that it is my song? Say plainly, say yes or no. That is more than enough for me. I'll explain it later on. Can Lata Mangeshkar claim copyrights in all her songs? That this is my right. Yes or no?
Yes, some of the answers are yes, some of
Ah,
are no.
no, some are, so that is no certainty about it. Lata
Yes.
Mangeshkar cannot claim copyright because if she alone sings without music, without soundtrack, will it be that effective?
No.
So that is what is right related to performers, broadcasters, and sound recorders. That is what is related rights. Yeah. When there are performers and it's a collective right of a person. Yeah. Had not the lyrics written rightly, had not the composition been done by a music director, would that song have been so famous?
No, sir.
Yeah. So that's what the copyright is talking about, related rights. Yeah. So this is what in plain the intellectual property is all about. Or kinds of intellectual property, or what exactly intellectual property revolves around. There are three things which are most important where the IPR, all the kinds of IPR revolve around. The technical issue, the legal issue, and the economic issue. We call it a TLE. Technical issue, what is to be protected. Legal issue, how it is to be protected. The economic issue, how to commercialize the protection. Yeah. Now, my next slide will explain this to you. It is one product and many IPR, but how does that starts with? Just imagine when the pen, the writing instrument, was invented many years ago. What would have been happened? It was in this form. Yeah. So patent for an ink pen that could store the ink. Before storing of the ink, we used to write with the branches of the tree. Yeah. There were no instruments. So somebody created this instrument. So he could store the ink. That was a technology. Though it was a very nascent technology in those years, but it was a technology. Nobody knew how to store the ink. Yeah. Utility matter grip pipette for the injection of the ink. How do you put the ink inside? Yeah. Huh? Now we have a ready-made things. But that time nobody was there. Then industrial design for smart design with grip in the shape of an arrow. Yeah. This was just like, this was the design. Now there are so many other designs for this page, conventional thing. Will you buy this pen? Will you buy a good pen? I'll give you a costliest pen. It is a gold, made up of gold, but it does not have a brand. It does not have a brand. Will you buy that? Will you buy that pen? So trademark for providing one product and packaging to distinguish it. Yeah. Like Mark, I have written completely. Which pen you are using, Surbi ji?
Sir, I am using cello gel pen.
But there is a brand. It has a cello. There are so many other brands. We have Cross. We have Parker. Yeah. So many brands are there. Lamy, this, that. So just imagine you're surrounded with intellectual property every day. Yeah. So this is what the legal issue, the technical issue, and the commercial issue is. The legal issue is what is to be protected. If I have to protect pen, I have to protect only the technology for storing ink and putting ink, or I have to protect the design, or I have to protect the brand, or everything. So one product, many IPR. That's the concept it's all about. Yeah. Now, how many of you want to really learn intellectual property from the conceptual to the fundamental principles and in and absolutely perfectly? How many of you learn? Or you just want to learn for the practice point of view or the increase in practice point of view? How many of you? But even for the practice purpose, you will not be able to know if you know fundamentally, absolutely important is that. Yeah. Now, what did happen in 1995? I hope everybody is born by that time. Because my students do say that I was not born. Yeah, I am a professor also. So when I used to teach in college, so I asked some students what happened in 1995. So some smart fellow said very smartly, "Sir, I was not born, so I don't know." Yeah, I don't. I hope even if you are not born, you should know what happened in 1995. What happened in 1995? Yeah, anybody can guess what happened in 1995? Because of what happened in 1995, we are sitting like this today. Otherwise, it would have not been possible to sit like this. I have given you the hint also now. Yeah. What happened in 1995? Is anybody able to answer, Surbiji?
Sir, I've not received any answer for this yet.
Yeah. In 1995, internet was born. Yeah. Because of which today our life will become paralyzed if there is no internet. Before 1995, life was paralyzed because there was no internet. But life was not paralyzed. Life is to run in that pace only. Today it runs in a different pace because of internet. So internet was born. So internationally, everybody thought that what we need to understand international trade is not only general agreements or trades or tariff. We need to understand in different aspects of that. And one of the aspect was trade related aspects of the intellectual property. And that is where an agreement was signed, a WTO was formed in 1995, and there are as many as 18 different agreements, out of which one of the most important agreement was agreement on trade related aspect of the intellectual property, which is called TRIPS. This is just like articles and memorandum of association of IPR. Everything is written about IPR in this. If anybody wants to learn IPR in depth and in proper manner, he should first read what is TRIPS. It has something like 8 or 9 chapters and more than, I think so, something 70, 80 articles. Yeah. It's everything about IPR, what IPR is, how that are created, enforced, what type of IPR are created, and how reciprocal arrangement is also done, how you have trademark in India, how can you protect outside India. Everything is written in this. There were many conventions on different IPR. They were all combined together. We brought something called, it is an annexure to W, most comprehensive coverage till date, incorporating substantive provision of many other conventions. Like Rome Convention was on copyright, Paris Convention was on industrial property, Berne Convention was again on copyright, integrated circuits, everything together. They made a master document, what is called TRIPS. If you need to understand IPR in depth, you need to understand what TRIPS talks about. Yeah. So it's everything, it is there. Enforcement provisions are there. How would you enforce your right outside India? With or without protection, with or without registration. Everything is written in TRIPS. Yeah. So this is just an absolutely graphical presentation of what I was trying to say. Yeah. So now I'll go to the most important aspect is trademark. One of the first intellectual property is trademark, and that is something which is very, very important in this country. What is trademark? Trademark is graphically represented a mark capable of being represented graphically, capable of distinguishing goods or services of one person from the others. It may include shape of the goods, their packaging, and combination of colors. It includes everything. Yeah. Various things are protected today. A mark capable of being represented graphically, capable of distinguishing the goods or services of one person from another, may include shape of the goods, their packaging, and combination of colors. So, what is in a form of different graphical representation? It could be a ticket, it could be a label, it could be a heading, it could be brand, it could be even a device, pictorial representation, symbols. Then heading means what it is, label, composite mark, printed, pasted, attached, ticket, stitched or tagged to goods loosely attached. Yeah, these all are something which is covered in what is a mark and what exactly is a trademark. Yeah. Now, procedure for registering a trademark. The process for registration of trademark is as follows. If required, take a search. When I say if required, if suppose if you have a coin or invented word, yeah, if suppose you have a coin and invented word, and if you are confident that nobody has this word, you may not even take search. Yeah, like one of my client is to deal with planning and manpower. Planning manpower, and for that he had a backup of database. So he branded his company's product as Plada. Planning PLA and database का DTA. So Plada करके दो word कर दिया. I was sure nobody was having this word. So when you have a coin word and it has no dictionary meaning, it becomes very, very effective trademark. You need not even take a search. But then if you have something which is a fancy word, take a search. See who else is anybody having such kind of similar good. Make an application with the representation of the mark. The trademark registry will examine the application and issue examination report. You need to reply to it. After replying, there may be a hearing. If the hearing is there, you need to represent your case. That's where the trademark, you have to appear. And when you have to appear, you have to be confident of two provisions of the Companies Act. One is Section 9, sorry, not Companies Act, Trademark Act. One is Section 9 and one is Section 11 of the Trademark Act. So Section 9 talks about the grounds on which trademark can be refused absolutely. And Section 11 is a ground which is called relative grounds. I'll come to that. But let us in brief understand this process. If you represent it in a proper manner, the trademark office accepts the trademark and advertises in a journal, which is called an official gazette. If that journal is kept open, that journal is kept open for 4 months to any third party to oppose it. If suppose there is an opposition, you need to fight that opposition based on the provisions of the Trademark Act. If the opposition does not come, the marks goes for registration. So in a nutshell, this is the process of trademark registration. Yeah, Surbhiji, now I would like here the people or participant to ask me what is exactly they want to know in this process. So this is where I want to understand where is the difficulty of understanding a trademark.
So one of the question is how a CS can be attorney for trademark.
We have a provision and we can represent it in a trademark office. We can become a registered agent. If you are becoming, if you want to become more purposely, you can even appear for exam. Though exams are not compulsory for company secretaries, there are trademark agent exams also happening now. So appear for that exam and you can become trademark attorney like that also. Otherwise, also you are allowed as a company secretary to register yourself as trademark agent.
Sir, one of the participant asked, unable to understand ticket for the trademark that we have discussed in the last slide.
Ticket is actually, see, they were in sports, there were certain clubs, and those clubs is to issue tickets, and those tickets were recognized as trademark.
Sir, like we have Rotary clubs or
yes,
Gymkhana clubs, so they issue the tickets in the form of like a pass or something like that.
Or something like that with their logo, and that ticket was having a specific kind of a shape and a color nobody else was allowed to use. Today also it exists.
Okay. So one question is, it is observed that there are certain trademark applications against which it is mentioned class 99. How do we make such application?
Class 99?
Yes.
No, I am not able to understand this question. Ask him to clarify because there are only 45 classes.
What is the distinctive character in section 9?
He is what he's trying to refer to is that, see, when I have to apply for more than one classes, say I am applying for 4 or 5 classes, I apply with single trademark application. That is what denote is class 99.
Okay.
Yeah. So single application in multiple classification. But I would suggest not to do it, because if your trademark is to be registered, is rejected in one class, your whole application gets rejected. Or otherwise, you will have to bifurcate that application in 4 different applications, and you will have to go for that process and procedure. So always apply differently. Yeah, it's a question of cost. But to save the cost, either you spend earlier or you spend later on. It is one and the same. Are you able to understand? Like, I'll tell you one thing. Like, I have a Plada as a trademark. Now I have to apply in class 3, class 9, class 12, class 18, everywhere. So I make a single application. That is allowed as per Trademark Act. But suppose now my mark is having sensitiveness in class 18 and it is likely to be rejected. So then the trademark office will have to reject the whole application. It cannot reject the part of application. So never do that. Or he will say that you divide your application in 4 different classifications because your one classification is sensitive. So they will allow you to do that. But then when you divide it, you have to pay the fees again. So there your economic of benefit will not survive that time. So better apply separately. That is my question. Is that, see, I don't understand one thing about that. That's not the pertinent problem which professionals need to handle in this country. You are creating a property. Why should you bother about cost? It is not the cost. Trademark or any kind of intellectual property is an investment. It is not a cost. The day we are professionals able to explain this to the whole world, we will be the most successful professional of IPR. IPR is not cost. It is an investment. And I'll tell you how it is. Yeah.
Sir, another question is, what is the difference between trademark attorney and trademark agent?
Trademark attorney is, yes, I am the power of attorney holder. So as a trademark attorney, I can represent. And trademark agent is somebody who has passed the exam of trademark agent. There are exams which are conducted by Government of India, and there are people who appear for that exams.
Sir, another question is how to prepare for hearing matters.
You should be very clear as to what are the queries raised in your examination report. It pertains to section 9 or section 11 of the trademark. It is very clear. I'll come to that section 9 and 11. I'm just on the procedure part, but I'll explain you what is the difference between section 9 and section 11. Section 9 talks about the absolute grounds of refusal and section 11 talks about the relative grounds. What are absolute grounds and what are relative grounds? I'll explain you with case studies and example. Just give me 5-10 minutes. Yeah. Any other questions?
Yes, sir, there are so many questions. So should we take up now or some later?
Pertaining to process and procedure, we take it now. Then otherwise we'll take it at later stage.
Sir, one of the question is how can we check the general of trademark?
It is published every Monday online.
Over the website of
Yes,
trademark.
IPA. Every Monday, whatever hearing happens or whatever trademark are accepted during the year, every trademark office has a particular day to publish a journal. Like in Mumbai, it is Monday. Maybe Delhi may have some other day, or I think so it's common. Sometimes it is common, sometimes it is different, but they publish a particular day that journal and they notify it on the site.
Sir, one of the question is how a CS can send the notice for infringement of trademark.
Why he cannot be registered? If he's a registered trademark attorney, he can.
And another question we have is difference between TM and R mentioned on the products.
Yeah. So when you apply for trademark and it is not get registered, you're claiming a trademark. When you're claiming a trademark, you write TM in circle. But when the mark gets registered, you're required to write R in circle. So that's the difference between TM and R. So when you apply for trademark and you are claiming a trademark, it is called TM. And when it gets registered, you write R.
Okay.
Yeah. So move ahead. Again, we'll stop at after 2-3 slides and you ask questions to them about the trademark. Yeah.
Sure.
Is that going correct? So
Yes, sir. Yes, sir.
Yeah. Yeah. So grounds for absolute result. That is section 9. Devoid of any distinctive character. The first requirement for a trademark is that your trademark should be of a distinct character. Distinct character means what? Distinct character means it actually, in a very first nature, it is of able to distinguish the goods of which you are representing as a graphical representation. It is different from the others. The second is it is capable of doing this. It may be a generic term, but you write in a particular format or a particular style, and it is capable of distinguishing your trademark with others. It may be inherent capability in inherently distinctively, or you are able to do it when you are using it and capable of distinguishing itself. That is what is you have to prove. They may say that it is devoid of distinctive character. You have to explain how you are not devoid of distinctive character. You are distinct. You are in what manner distinct? By way of, it can be by way of a user. When you are using it and nobody has created an objection, that itself says that it has acquired distinctiveness. The user is one of the characteristics or a feature for that. Secondly, you are written in a particular name and style, and that is unique. Nobody else is having. That is called as capable of being distinguishing your that. That is the difference between one distinctive character. It serves to designate a kind, quality. It should not talk about anything about kind, quality, quantity, purpose of the trademark. Geographical names are not allowed to be trademark. Production of goods and rendering the services and characters of goods or services. You don't talk about in your trademark, it should not talk about quality, quantity, purpose. Geographical names are not allowed as trademark, except there is no connection between the geographical name and the trademark. Then only exceptionally geographical names are allowed. Otherwise, geographical names are not allowed to be put. And they have become customary in the current language or in bona fide established practices of the trade. Every industry had certain trends to use certain words. Like when we say that A1, A2, A3, if it is customary, you can say that it is customary, though it may be a generic term. Secondly, the generic trademarks are allowed to be registered provided its long use is there. Like the best example I can see is stay free. Yeah, stray free, if you see, it is against the principles of what is written here. But because of the user, it has characteristics of distinctive characteristics. No other stray free is there in sanitary napkins. There's only one stay free. So you're able to say that it was acquired distinctive character by use. So that is what is the absolute ground for refusal. That absolute ground of refusal, you have to counter remand this with this type of actually defenses that you have a distinctive character in terms of 9(1)(a) or 9(1)(b) or use or inherent capability to distinguish. I'm not talking anything about quantity, quality. I'm talking absolutely plainly my brand is there or they have customary in business or current language. That is one of the differences for this. Acquired distinctive character as a result of use, as I said, or it is a well-known trademark. You have been using it for years. You have been using it for years, and in industry, all over the industry, you are well-known by that mark or well-known by that name. So it is a well-known trademark. These are the exceptions for you are in absolute grounds. Secondly, it should not be descriptiveness. The trademark is not descriptiveness. It should not talk about quality, value, geographical production of goods or rendering, like quality and quantity treat for dessert or sauces, fruit loop for cereals, lasting performance for perfumes are held descriptive. Then intended purpose, perfect bro for cosmetics held descriptive. Telia International applied vacuum packing machine held descriptive. Perfect bro. Then Telia or say anything which is directly pertaining to the feature or the functions of the goods to which your trademark represents cannot be used as a trademark. It becomes descriptive word. Yeah. Then the relative ground. The relative grounds are identity of trademark with earlier trademark and similarity of the goods. Yeah. It could be the identity similarity of the goods is phonetic similarity. It could be structural similarity, or it could be, say, phonetic, structural, and visual similarity. These are the three similarities which the trademark office considers. Either it is phonetically similar, you prove that phonetically it is not similar. or structural. Structural means the number of words, the way it is designed, the way it is put, the way it is represented on the product is structural. And visual. When you compare these two, you can say that there is a similarity of goods and services. So there is an identity of, say, trademark, which is earlier trademark in the similar goods or services. Identity and similarity of the trademark, but goods and services are not same. It's not same. I am using it for totally different purpose. Like I have a trademark called Crystal Vision. There was a company which is very famous for, say, this kitchen appliances which use the word crystal. They objected my trademark. And I was not using that Crystal Vision for the purpose of kitchen and home appliances. I was using it for a scanner or the scanning machines. So it was for totally different goods and services. So if it is different goods or services, you can say that, and the word was Crystal Vision. I had a suffix. That could be prefix, that could be suffix. Add prefix or suffix when you have such type of issues. Similarity of the goods with the same goods and services or with the goods and services other. Identity should not be exactly similar. If it is identical similar, nobody will give you that trademark. There has to be prefix or suffix, and that prefix and suffix should justify the provision of the law. If you have this, you will be able to do. Or you claim well-known mark. Well-known mark again. So these are the kind of grounds which are available for trademark, which on this basis the trademark applications are examined. You need to deal with them. You need to understand what are the provisions of the law. You need to understand how other applications are dealt with. You need to read certain judgments, how it is held. You need to understand and make your case. If you are thorough with the provisions of section 9 and 11, I don't think so you will have difficulty in appear before the trademark law or trademark authorities. Yes, now we can go back to the questions, Surviji.
Yes, sir. Is there any protection for unregistered trademarks which are in use for a longer period?
Yes, why not? That will give you more. In fact, I'll tell you one small story or a case study. Dabur was never a registered trademark till 1996. They started their business in 1949. Till 96, it was not a registered trademark. So some Bengali fellow in Calcutta thought that this is not a registered trademark. He got the same trademark registered for his textile products. And he was selling actually the lungis in Calcutta. So Dabur came to know. He said, oh, why is this happen? Because they are not a registered trademark. They applied for injunction without trademark being in existence. They applied for injunction that produce the certificate. He said, these people are existing for 50 years. It's the goodwill of a business and the product which creates a trademark. They cancelled his registration and then trademark registration started. Every product got started registration in Dabur. You know what is the meaning of Dabur? Dabur का मतलब क्या है? Dabur का मतलब क्या है? सुरभि दिल्ली की कंपनी है आपकी?
हाँ सर, दिल्ली की कंपनी है. इनफैक्ट मेरे घर के काफी पास ही है.
हाँ, फिर Dabur का मतलब है डॉक्टर बर्मन, who was the promoter of that company. So that's a coin word. Yeah, can you copy that coin word just because it is not registered for 50 years? What is important is who is first in point of services of use of that trademark. That is one way at looking at trademark. But if there is a use is very less or similar to the conflicting mark, who has first made the application for trademark, he has a better right. So there are two ways to look at the trademark application. One is who is using for long periods. Say I am existing for last 10, 15 years, but I am not registered, fine. But if I can prove, like in one of the cases I had, that my brand was actually existing since 1979. And somebody came in 2000. But I could prove that I am existing since 1979. So I have a better right than the other one.
So another question we have is, what is the certification trademark? Who can apply for this category? only government company can go for certification trademark, or a private company can also do so?
No, certification trademark can be done by anybody, provided there are sets of provisions you have to apply. You will need to have your, like EGMARC. EGMARC is one of the best examples for certification trademark. Or ISI is again, and that is not allowed to be used by anybody individually. It is given on the basis of certain parameters, and you need to be a member of that association. That association allows you to use that particular mark, and that is why it is called certification trademark. So certification trademarks are only held by certain associations or people. It's not necessary that it has to be government. It could be anybody.
So one of the query is that a mark is on objected status since last 6 years. And the applicant has filed all the required documents and attended all the hearings, and yet that mark has not been registered. So what is the advice for the further steps?
Appoint me as a lawyer, I'll get it registered. No, there are open session happening on like trademark office has some particular dates. There are open session happening in every offices like Bombay, Calcutta, Delhi, and Chennai. The whole trademark office has open session. Attend that open session online and please raise this issue that this is in, and press it or write to the CG directly. Obtain his email. It is available in every office and write to him with all the facts and detail. He helps you. He has helped me. He has helped me. And it is not that these people are not helpful. They are very helpful. Provided we need to be professional in our attitude and approach. We should not show our attitude that 6 saal ho gaya, ye karte hai, wo karte hai. They have their own limitations. So it is possible. Apply it in a diplomatic manner. Go and attend the open session or write to the Controller General. They will find out the reasons and they will help you.
So another question we have is, what should we keep in mind while drafting examination report?
What are the queries raised? The queries raised could be for only absolute ground or relative grounds. Or if there are some administrative queries, they need to be addressed. Like sometimes they say that power of attorney was not there, or you have applied in wrong classification, change the classification. So then you need to follow the process and procedure as prescribed by the trademark office. So what is written in the examination report, it depends on that.
Okay, sir.
Yeah. Yeah.
So one more question we have.
Yeah, please.
Time period in which registrar will register if reply has been given after initial observations. No further observation came from last 1 year.
So they will call for hearing. It should show within some time as a status will show that mark for show cause hearing. They say that they call it as a show cause hearing. So it will call for show cause hearing. And if there is not done for a longer period, I told you, go to the open session and send that, please mark this for hearing. Yeah, or write to the Controller General. He will push through this for show cause hearing. It is possible. हम V3 नहीं चलता है, V2 नहीं चलता है, तो रोके बैठे क्या? नहीं बैठे ना हम लोग, किया ना कुछ रास्ता निकाला ना, तो इसका भी रास्ता है. But it has to be done in a proper manner. Yeah, don't behave arrogantly and don't behave angrily. Yeah, always there are problems. They have a huge backlog due to COVID. Yeah, but होता है वो. I am been practicing for 22 years, 23 years only in trademark and corporate. I have also issued. So I go and approach diplomatically. They said, do this, and I do this, and they have helped me. Believe me, they are helpful. It is not that they are not helpful. Yeah, go in a proper manner, understand why it is not gone, speak to them, understand their difficulty, try to help them in their difficulty, so they will help you in your difficulty. Yeah.
So we can take one more question. If in case hearing officer rejects the application, what we can do? Can we appeal somewhere else?
Yes. Rejection, if the trademark is rejected, you can file a revision application. It will again go to the same officer, but you try to explain your point again. If there is revision is always, if you have, your law point is very clear that you are absolutely entitled for it, file a revision application. If it actually gets even rejected in revision, you can go to High Court.
Sir, I think we can move forward with this.
Yeah. So few examples of trademark: name, word, numeral, packaging, signature, letter, shape of the goods, combination of colors. Yeah. Huh. Numerals, may I would say that textile is the industry where numerals are used as trademark, like 2 by 2, 2 by 18. In numbers, even in metal, certain metal industries, numbers are very important. Say this mm, that mm, and all that. Packaging, yes, packaging is also entitled for trademark. How many of you have gone to McDonald's? Next time when you go to McDonald's, ask him to give the burger in a packaging material. दे हैव अ पैकेजिंग बैग, हाँ झूले जैसा बैग है, वो बैग में लीजिए, वो बैग को प्रिजर्व कीजिए, यू एंजॉय योर बर्गर, नोबडी सेज नो टू इट, बट वो बैग मत फेंक दीजिए, बैग के पीछे देखिए इट इज रिटन दिस पैकेजिंग मटेरियल इज द रजिस्टर्ड ट्रेडमार्क ऑफ मैकडोनल्ड यूएसए. So packaging also is entitled for registration of trademark. Yeah. Then shape of the goods is also registered as trademark. Letters are there, signatures are also registered as and combination of color. You claim all the color combinations when you apply, and it is entitled. You are entitled to it. Yeah. Types of trademark. See, these are the types of trademark. Yeah. Types of trademark. Nike, just do it. There are three components to it. The Nike word mark, then write is the device, and just do it is the punchline. Then Starbucks. Starbucks is the word, then there is a queen or a princess, and the color. Color, see, the Starbucks only uses one kind of color. Yeah. Then you have ISFI as a certification mark. I told you. Then Apple's logo. Then geographical indication. You even Darjeeling tea, it can be used as trademark also, and it is used as geographical indicators also. Yeah. There's always a kind of a competition whether you should go for geographical indication or you should go for trademark, particularly in agriculture industry. Yeah. So these are the some types of trademarks, like Nike, just do it, Pepsi, product and services, Cambridge University Press, logo and the word. So these are some examples of different types of trademarks. Then we go to the next is the patent law and procedure. What is patent? Yeah. Yeah. So patent says that it is a legal grant given by the state to the inventor. It's a bundle of rights granted to an inventor for a consideration or an incentive in investment in his research. It's a contract between the inventor and the state for a limited tenure. See, what patent says that it can be protected, as if you remember the first slide in types of intellectual property, we said that industrial property. So in industrial property, if you have invention, it qualifies for patent as a registration. So when it qualifies for a patent as a registration, you need to have that eligible invention. What are eligible invention? Any invention which has novelty, which has utility, and which has the inventive step involved is qualifying for an invention as a qualified invention. And if you prove it, it is absolutely entitled for a grant, legal grant in the form of a patent. And this patent is valid only for 20 years from the date of application. Whenever it is granted, the application is retrospective effect. All the IPR are having retrospective. Even the trademark, if you have a user and if you apply, say someone later, say I am using it since 1999, I apply in 1920, the application will be valid from 1920 whenever I have get that registered. So it is all retrospective. The IPR right starts when you have applied for it, and the statutory right is given when you get registered. It is always from the date of application. That's what how the trademark and the patent law works. So what is patent? A grant to the inventor for an eligible invention. Eligible invention is that which has novelty, utility. Here utility is commercial utility, not the general, and inventive step. So patentable subject matter. It relates to product or process or both. New product, new process altogether. It is entitled for subject matter of patent. It should be new or a novel. Yeah. Involve an inventive step and be capable of industrial application. Industrial application is the commercial utility. So this is the patentable subject matter for an invention, that it has to be new, or it could be a product or a process. it has to involve an inventive step, be capable of industrial application. And it should not fall under Section 3 or Section 4. Section 3 of the Patent Act talks about the patents which are not registrable as patent. There are certain categories of patent or certain categories of some subject matters which are not qualifying for patent, like medical and method of medical treatment. They are not. Even in IT, it is said that computer program per se, only if it is a program per se, it's a general computer program, it will not fall for patent. But if it has a technical advent, it can still go for a patent. What do you mean new? It is not published in India, not been prior public knowledge or public use within India, or claim in any specification in India. Specification means a patent specification. A patent specification is a particular document which requires certain things to be mentioned in that document, and that document is given along with the application for patent. So for a new, it should not be published anywhere in India or outside India or anywhere in the world. It is not in the prior public knowledge or public use within India or outside India. Claim in any specification. Yeah. What is an inventive step? Involves technical knowledge as compared to existing knowledge, must have economic significance or both, or it is not obvious, must not make it obvious to a person skilled in art. Now, who is a person skilled in art? A person skilled in art is an expert who is dealing with that subject or the invented subject matter for years. So let me explain you this with a small example. What is technical advance against the technical compared to existing knowledge? Economic significance, or it could be non-obvious to a person skilled in art. Everybody has mobile phones, correct? Everybody has mobile phones. If your mobile phone is that able to access data of a computer or a system which is there in your house and which is there in your office, is it possible? Is it possible? Say yes or no. Yet, सुरभि जी देखिए क्या बोलते हैं लोग.
Yes, sir.
It is possible. My mobile access to the data which is there in a system in my house as well as in my office. Is it possible through your mobile?
No, sir, I'm waiting for the answers.
Yeah. So, has anybody seen this type of technology anywhere? I'm asking a simple question that I have a mobile. That mobile has a feature, or is that feature, it accesses the data in a system which is lying in office, or a system lying in my house, or in both places. Is it possible?
Yes, sir, the answers are yes.
Have you seen such type of application? Have you come across such type of, say, technology?
So for this question, the answer is no.
So you have not seen the technology, but is it not possible? It is possible.
It is possible.
It is possible. So it becomes an eligible invention which involves technical knowledge as compared to existing knowledge. What is existing knowledge? I have everything detailed. मेरे ईमेल में सब कुछ है. So ईमेल मेरे कंप्यूटर में है और कंप्यूटर के डेटा मेरे पास मोबाइल पे है. But I am not talking about email. I am talking about a particular file or a data. So if this is possible, that is also possible. Somebody may come out with this where I have an access. And have you heard about that? If you are gone out of your house and you're not knowing whether you have switched off your fan, tube lights or everything. नहीं मालूम. अभी मैं क्या करूं? मैं वापस घर जाऊं? I'm already out from my house and I'm 60 kilometers away from my house. If I go back, then I'll not be able to serve the purpose where I'm going. So is it possible कि मैं मेरे मोबाइल से मेरे घर का डेटा एक्सेस करता हूं एंड स्विच ऑफ नहीं है तो स्विच ऑफ हो जाएगा?
Yes, sir. These technologies are available.
Available, yes.
Yes.
So such type of domains, when they have technical advance as compared to the existing knowledge, they are eligible for invention. It has an economic benefit also. Yeah, कितना पैसा बच जाता है.
Yes, sir.
This is obvious. Is it obvious or it is not obvious? It is possible, but is it very obvious? It is generally ये तो कोई भी कर सकता है. ऐसा है क्या ये?
So it's not that obvious. It will
Yes,
take
it's
lots
not
and
that
lots of
obvious.
effort.
So when it is not that obvious, it becomes not obvious in person scale of art. Like a person who deals with this technology says, नहीं ये मैंने पहले कभी नहीं देखा है. So when he says that, it means it is not obvious. So these are the features of an inventive step. So just to go back again, a patent requires three things. One is novelty, second is utility, and third is the inventive step. Novelty, something which is altogether new, not known in public domain anywhere in this country or outside India. Utility is the commercial utility. And the inventive step. The inventive step is technical advance or an economic executive gains or both, and it is not obvious to a person skilled in art. Is it clear? Yes? Yeah.
Yes.
Huh. Now we go to the next topic is copyright. Yeah, subject matter of copyright. Yeah, original literary work, dramatic work, artistic work, musical work, cinematographic film, sound recording, or work of aesthetic and craftsmanship, or work of sculpture. Yeah. So these I have dealt already, but let us see how copyright works. Requirement of copyrightability. It has to have the originality and it has to have a fixation. So when I say originality means it has to be new. Again, it has to be new and it has to be in some manifested form. Suppose आपने कौन सा लेटेस्ट पिक्चर कौन सा देखा सब लोगों ने? Have you everybody seen that movie कल्कि ना क्या कल्कि पिक्चर आया ना अभी? हाँ?
Yes, sir.
देखा आपने देखा?
Yes, sir.
हाँ? So कल्कि की स्टोरी बहुत टोटली डिफरेंट है. करेक्ट? You know what concept is there in कल्कि? कल्कि में कंसेप्ट क्या है? आपको मालूम है क्या कंसेप्ट है टुगेदर?
It's about the Kalki avatar of Lord Vishnu.
हाँ, कल्कि अवतार, बट उसमें सबसे बड़ा कंसेप्ट ये है कि आपको मालूम होगा शायद, पता नहीं, महाभारत में ऐसा लिखा गया कि अश्वत्थामा आज भी जिंदा है.
Yes, sir.
या तो वो अश्वत्थामा को बेस लेके, कैन यू से दैट अश्वत्थामा इज ओरिजिनल या इज विष्णु ओरिजिनल? ये तो सबको मालूम है, तो फिर ओरिजिनल कैसे हो गया? But the way it is put in that movie, the way it is made as a medium to explain something, yeah, उसमें explain क्या क्या है कि वो एक प्रेग्नेंट लेडी को मारना चाहता है और वो प्रेग्नेंट लेडी को कैसे वो बचाता है, अपनी शक्ति से बचाता है, और एक आदमी जिसको वो छू लेता है तो he becomes totally different. So all this imagination, see I told you imagination is more important knowledge. विष्णु was existing, अश्वत्थामा was existing, हमने imagination डाल दिया उसके. So when you put that imagination all together and absolutely you bring originality, that is what is originality. Yeah. Can I say that I had a thought of this story? मैंने ये पहले ही सोचा था, ये तो मेरा कॉपी किया है. Can I say that? सबने विष्णु के बारे में पढ़ा है, सबने अश्वत्थामा के पढ़ा है, किसी ने ये बोला कि ये मेरा कहानी है? कोई बोल सकते हैं ऐसा? क्यों? Because this man had written in the form of a script and it is now developed in a form of a film. So both the script and the film has an originality. So it is manifested. I cannot say it's my idea until it is manifested in some form. So these are the basic requirement of copyright. Now I don't know whether I've covered one more slide.
Yes, sir. We can cover one more slide.
Yeah. No, I want to tell something different. Let me complete this first. So what are the copyrights and related rights? Scope of copyright protection, basis of related rights, and period of protection. Now, period of protection is very important in copyright. It is 60 years or the life of author, whichever is later. So that's the what is it. Now let me come to a very important thing, how copyright can play an important role. Suppose मैंने कल एक डिक्शनरी बनाई which is all the meanings of important provisions of Companies Act, important provisions for secretarial audit, important words and meanings for LODR, important words and meanings for say क्या हो कौन सा है वो insider trading law, सेबी लॉज देन कॉर्पोरेट लॉज, सबका एक डिक्शनरी बनाया. क्या ये डिक्शनरी हम प्रोटेक्ट कर सकते हैं एज अ कॉपीराइट इन अ फॉर्म ऑफ अ लिटरेरी वर्क? लेट्स अंडरस्टैंड दिस.
So these are the laws which are available in the public domain.
उसके इंपॉर्टेंट वर्ड्स एंड मीनिंग्स है, करेक्ट. और एलओडीआर का मतलब क्या है, रिलेटेड पार्टी ट्रांजेक्शन का मतलब क्या है, नॉट विथस्टैंडिंग का मतलब क्या होता है लॉ में, सब्जेक्ट टू दिस, सब्जेक्ट टू दैट, इन सबके वर्ड्स एंड मीनिंग एंड इंटरप्रिटेशंस मैंने दिए और उसका एक डिक्शनरी बनाया मैंने. कैन वी प्रोटेक्ट दिस एज अ कॉपीराइट?
The answers are coming as no.
Why no?
Because of the originality.
ओके क्यों ओरिजिनलिटी क्यों नहीं है इसके अंदर?
And now with this, some of the participants are saying yes, we can protect it as a, we can register it as a copyright.
Why you can protect it as a copyright? Now there are people who are saying no and there are people who are saying yes. So let us understand those people who are saying no, that there is no originality. The yes people should prove how there is originality.
They're saying already in the public domain and it's a form of a compilation. So,
Okay, yes. Now let me change a little bit questions. I have arranged all the words and meanings alphabetically. I have changed and written every word like A, B, A, C, A, Z तक जो भी आता है वो एक जगह पे है. B, A, B, C, B, D जो भी आता है वो एक जगह पे है. ऐसा Z तक जो भी वर्ड आते हैं सब कंपाइल करके अच्छे से मैंने उसके थिसॉरस भी दिए, सिनोनिमस टर्म भी दिए हैं मैंने, और उसका इंटरप्रिटेशन जो भी था कोर्ट में डिफरेंट, लाइक एनसीएलटी ने कोई इंटरप्रिटेशन दिया है, सैट ने दिया है, सेबी ने दिया है, स्टॉक एक्सचेंज ने दिया है, ये भी सब मैंने डाल दिया है.
so members are saying only yes if it presented in a different manner or if it is a unique.
What is the different manner? What is the different manner?
If it is a special method.
What is the special method? मेरे कहने से स्पेशल मेथड नहीं हो जाता है ना वो.
Some of are still saying that it's not copyrightable as it's already in the public domain and it's just a compilation.
Public domain, yes.
And it's just a compilation of the words from the act.
बट किसी और ने तो दिया नहीं ना ऐसा डिक्शनरी. आज तक किसी ने ऐसा लीगल डिक्शनरी निकाला है? Have you seen anywhere any legal dictionary like this? So originality तो है ना फिर.
It contains originality, but it doesn't mean that some other person cannot have that idea and have that dictionary.
But nobody had it. I am the first person to do it. If he had, why he didn't do it? Nobody stopped him from doing it. I have done it.
So the answer is it can be registered as a copyright if there is no any other dictionary like this.
There is no other dictionary.
Same answers are coming if it is presented in a different forms or as a database.
Let me put one more question like this only. You have different judgments of SAT, SEBI, NCLT, correct? तो ये जजमेंट्स के जो बुक्स आती है ना उसमें वो लोग कैच नोट और हेड नोट देते हैं एंड फिर जजमेंट का एनालिसिस देते हैं. कैन दैट बी प्रोटेक्टेड एज कॉपीराइट? इट्स द सेम थिंग ना. इफ यू सी द कंसेप्चुअली बोथ द सेम थिंग, दे आर आल्सो अवेलेबल इन पब्लिक डोमेन. मैंने अपनी तरह से दिया है, मैंने क्या क्या इंपॉर्टेंट फैक्ट्स थे उसके कैच नोट बनाए, हेड नोट बनाए और इंटरप्रिटेशन मेरे हिसाब से दे दिया. जजमेंट तो जजमेंट कोर्ट का है. That judgment belongs to that judge who has passed that judgment. But I have compiled it in a form of that I am giving a catch note, head note, and analysis. Can that be copyrighted? Both is this company. ये दो factors है copyrightability के, originality and fixation.
Some of our no, some of our are with yes.
Some of are not no saying no because there is no originality. It was existing.
Yes.
If somebody is saying yes because it is adopted.
So one of the answer that we got is facts cannot be copyrighted.
Facts cannot, but I am not writing facts. I am writing catch note and head note, which are not actually written anywhere in the judgment as facts. Am I writing those facts? जजमेंट में वो फैक्ट्स है करके नहीं लिखा है, उस तो जजमेंट ही लिखा है. मैंने उसमें से एक्सट्रैक्ट किया कि ये फैक्ट्स है, ये इश्यू था और कोर्ट ने ये बोला. हमारा चार्टर्ड सेक्रेटरी ले लीजिए, उसमें लीगल वर्ड में जिस हिसाब से देते हैं ना आप लोग.
Yes, sir. From past 4-5 months, we are giving the gist of ROC orders every month.
Yes. तो आप कॉपीराइट कर सकते हैं कि नहीं कर सकते हो? आप बोलेगे अभी वो इंस्टीट्यूट का मैटर है तो कर सकते हैं, ऐसा नहीं होता है ना. So what's the principle behind this? Now that is what Supreme Court says, that anything which a skill applied, labor applied, and judgment applied, anything which is skill, labor, and judgment applied can be copyrighted as original work. Though there is a similarity, it is existing, but I have adopted it. I have put my skill, I have put my labor to compile it. I have put my judgment to write in my way what the law is all about. So anywhere where there is a skill, labor, and judgment, even a dictionary can be copyrighted. Because it says that A, B, and it's giving synonymous. Nobody has done that. That's the skill. That's my labor and that's my judgment as to how I have put. I am stating whether this word is noun, adjective, वो सब भी लिखता हूँ मैं उसके अंदर. So that is my judgment and that is my contribution. The words are existing all over the world, but nobody did this. I'm making somebody convenient to understand that. So it has an originality. A film, a drama, और वो ड्रामा को फिल्म में अडॉप्ट किया या फिल्म को ड्रामा में अडॉप्ट किया. So when you do adaptation, it's again an original work. हाँ, लेकिन एक है कि ऑलरेडी ड्रामा है तो उसकी परमिशन के बिना मैं अडॉप्ट नहीं कर सकता है. I have to take his consent to do the adaptation. Here I don't have to take because it does not belong to anybody. It is there in the old world. Yeah, same way, Mahabharata. It's an epic. Nobody can copyright it in India in Sanskrit or Devangari language. But if Mahabharata is translated in Japanese language, Mahabharata is translated in Martini, that is copyrighted. Because again, that's an adaptation of an original work. And that also becomes again an original work because somebody has skill, labor, and judgment of doing it. Yeah. So that is what is all about copyright. Yeah. See, these are some best example of copyrightable work you may have come across. Cinematographic, film, music, work, सब कुछ है इसके अंदर. Yeah. Television, movies. Yeah. Geographical indication. So this is associated with place of origin, making its characters and quality dependent on the feature of such source, like Darjeeling tea. Geographical origin and geographical indication are used to inform consumers about the geographical origin of such products. These are the examples of some geographical indications. Kolhapuri chappal, penny, then this Jamdani shawl of Bangladesh, Darjeeling tea, tequila, Jamaican coffee, blended whiskey. These are some examples of geographical indications. What is design? Again, and another important kind of intellectual property. It is concerned with visual aspect of the article. Concepts like garden designs, the architectural drawings and designs, books, jackets, label, they are not applied. They're excluded. So what is say that when you have a configuration pattern, it has to be applied to some tangible product. Garden designing is not a tangible product. Architectural drawings are not tangible things. Books, jackets are not tangible things. Though they are tangible, they are in the same form when we receive it. Tokens, medals, buildings, and structures have been excluded from design protection. So when you say that particular kinds of patterns or shapes or the artistic creation, so it has configurations and patterns which are protected as design. Like this Coca-Cola bottle, sandals, iron, then this different kinds of bottles for different products. Yeah, this Coca-Cola bottle has its own IPR rights. This design, Samsung and Apple fought for this design in US courts, and Samsung was given an order to pay $250 million to Apple for this design. Yeah. So IP is an as a culture, business method, model innovation, reimagination of customer experiences, tapping new revenue streams. Why company secretary should learn IPR? Because it is something to do with commercial things. It could be business model innovations, reimagination of customer experiencing, and tapping new revenues. Ye economic aspects are there. IP protection stimulates economic growth on macro level. IP helps conversion of knowledge and information into income. IP should be factored by organization in their business strategy. The best example I can give is Gillette. Everybody knows about the twin bed technology, correct? Twin bed technology. So when twin bed technology was invented by Gillette, it had 6 to 7 designs before him. And he never knew which design will be successful. He had a basic design, then first design, second design, third design, ऐसे 6 डिजाइन्स थी उसके पास. तो उसको मालूम नहीं था कौन सा सक्सेसफुल रहेगा. So what did he said? Protect all the 6 designs. So he patented and did the design registration for all the 6 designs. The patent was on the mechanism to actually manufacture the twin blade. Twin blade were not existing before them when Gillette introduced it. So what happened? How now he has an IPR. He had an IPR, not an issue about it, protected it. But how did he use it as business strategy? That is very important. Yeah, what did he do? Then when the first design was launched, it became very successful. Yeah. So before the sale of first design went down, he launched the second design. Before the sale of second design went down, he launched the third. He didn't wait कि इसका sale कम होगा तो फिर मैं नया product लाऊं. He didn't wait for it. Like that, he went on introducing to all the 6 designs. You know what he did? He created a wall of IPR. He created a wall of product. And he created a wall of variety in such a way that he didn't allow anybody to enter that twin bed technology business. That was his strategy. He had IPR, but he used it IPR for business strategy. Yeah. So that is why you have Mac 1, Mac 2, Mac 3, Mac 4, Mac 5, Mac 6 tak gaya. Yeah. So how you can use IPR for your business? That is what the leveraging of IPR is all about. Yeah. See, this is what is important. Over 80% of market value of Microsoft is derived from its intangible, actually its intellectual property. The value of Coca-Cola trademark exceeds more than 50 billion. This was something in 2015 or 16. It is more than that today. Yeah, IBM earns only 1 billion a year from patent licensing. IBM is actually one of the second highest patentee after Intel. And it earns only 1 billion out of patent licensing. US patent license industry is more than 120 billion. It was very old record. Now it has crossed almost 300 to 400 billion dollars. So IP in digital economy, what it means all about? Protection of semiconductor chips, domain name protection. Domain name also has a characteristics of a trademark. It can be protected as a trademark. Database and data protection. This is something which will be coming. Information and technology and IP. All AI are protectable as patentable technology. How you are using that AI, what that AI is doing, how that architect is created, then again that you put it in a structure of novelty, utility, and inventive step, that will give you a different dimension altogether. Skill and knowledge have become the only source of sustainable competitive advantage. And that is where the skill and knowledge in the form of intellectual property is very important for a competitive advantage. Does your management structure have a scope to reflect the strategic importance of intellectual property? Now, this is what the company secretaries are required to do. It has to explain to its board that what is the intellectual property and what is its importance. Today's world is effective board is an innovative board. That's what I have written one of the article. If somebody is interested in my LinkedIn profile, I put it. An effective board is always an innovative board. Absolutely. An innovative board is something which respects intellectual property and it creates IP as a culture. TCS was given an award of the best IP company and the best innovative company in 2023 for 2020, 22, 23. And that award was given by Mr. Piyush Goyal, the Commerce Minister at that time. And that award was given by WIPO to them. It's an international body. And it was not that Indians have given that award. They defined the criteria and they get in. So one of the most important question was asked that how did you do it? They said that it's a culture. It cannot come one day. And that culture had come from the board of directors. It is the board who decided that we want to do this. And it's the board who said that we will have to do this. And that's what the new customer experience TCS is giving to all its existing customers. So leveraging of IPs, use IP assets, build business relationship and opportunities. It will help to achieve more than if you didn't have IP. In turn, it helps business profitability. I'll explain you this very clearly with this slide. This is the most interesting slide. Tell me what is the manufacturing, how many manufacturing units Amazon has? How many manufacturing units Amazon has?
Zero.
Zero. How many cars, how many hotels are owned by Oyo?
None.
How many restaurants are owned by Zomato and Swiggy?
None.
Zero. But these brands are most important than that business. What it means? Does Amazon manufacture itself anything? Yeah, now it has started little bit. Little bit it has started. But before 2021, it has nothing. Today also it has very negligible thing which it is manufacturing. 99% or it's only 2% say. But that also they don't sell it on their own platform. Is Zomato owning any restaurant? Is Swiggy owning any restaurant? Is Oyo owning any 5-star hotel or a property? But then these brands are very famous in that respective industry. Without them, that industry would have not survived. Yeah. Would have Zomato survived? Or would have Swiggy and Zomato made the restaurant business survive in COVID? Yeah. Now that's the business practices, new business practices. It's a brand. If you see, these are trademarks, most valuable brand in this country. And see the importance, see the strategy, see the business and the leverage part of it. They're not owning anything. They don't do anything in the business what they are doing it. But still they are very famous brand in that industry. That is what is the effect of IPR. Now, this was a very old invention. But see how much money that earned for that inventor. That is what is leveraging of IPR. Yeah, see how much he has earned. The inventor has earned. Who gave it to Coca-Cola. This was done in Oxford University in London. Yeah. This is one of the most important slides where the IP leverage can really work in this country. We have an academic community, we have business world. How many patents Amity files every year? Amity as a university. In fact, in 22, when the COVID was just getting over, one of the University of Punjab, I don't remember that name. It's on some of that guru's name, that university is. They got the highest patent filing award in India. You know what did they do in COVID time? There were certain students who were from very far off. Said, don't go to your home, don't take risk. You have got life, you have got opportunity. They provided all the infrastructure, all the resources, and they did all the students. There were some 80 students who didn't go back to their houses for almost 1 year because they were busy doing the research work and they created research and inventions in various fields, right from information technology, biomedical, biotechnology, even in IT, even in mechanical engineering, all types, they had filed almost more than 150 patents in 6 months' time. If this 6 months' time, whatever patents have been sold to this business world, the kind of amount the university is going to earn. That's what the leverage is. You will create startups, you will create successful entrepreneurs from university at grassroots level itself. If you combine these two domains together, that is knowledge and funding. Yeah, that is what is leverage of IPRS. Now I'll take two case studies about how do IPR help is. One is I'll take a first one, that is Pliva and Pfizer synergy story. And last, I will take it as a Kodak disaster story. Because the rest of two, if I go, I'll not be able to attend a question and answer because it's almost 4:45. So Pliva and Pfizer. Pliva was a company in Croatia. Yeah, it was a company in Croatia. And it was a very old company. And they were on the verge of filing insolvency. The insolvency laws came very late. They were there in the Croatian continent. They said that we will not able to work company very well. We are becoming a lot of liability. So they were on the verge of filing the insolvency. That's a part of one starting part of the story. On the other end, there was a company called Pfizer, which was a big multinationals in USA. They were working on a patent or they were working on a medicinal technology to introduce a very strong or a different kind of antibiotic. So they had very professionally managed company. They called the R&D that how much time it will take to develop this antibiotic, how much time it will take to develop it, how much time it will take to introduce in the market, and how much amount you will require for all this purpose. So everything was there. There were budget, everything was there. It was planning, everything was involved. And Pfizer was all set to do the investments. And they were supposed to release the first installment of money required for this project of this new antibiotic they wanted to invent and launch in future time. The finance department of this, they said, okay, fine, we'll release the amount, but let's understand what this business will earn and how much time it will. Is there any way we can quickly earn in this business? So what did they do it? They tried to see what are the existing patents and existing products in the market. And they came to know that this type of patent is available with only one company, and that is in Croatia called Pliva, who had a similar kind of antibiotic patent on this. He said, let's see what Pliva has earned out of this antibiotic. And they were shocked and surprised that Pliva is filing insolvency. So one of the idea which came to the finance guy is that if they are filing insolvency, what are they going to do that with that technology? If they are not going to use the technology, let's go and buy that. So they decided, they kept the whole project of Pfizer on hold. They went to Pliva and started negotiating and discussing what are we going to do to this technology. He said, we don't know. It's a patented, and that's a life patent for next 10 years. He said, we have 10, 15 years life for this patent. But we could not operationally manage. It is not that our technology was not good, but operationally we could not manage. So we are absolutely closing down. He said, will you sell this technology to us? So they went back. Pfizer people went back to their management. They said, instead of 3 years, we can do it in 6 months' time. We can do everything in 6 months' time. Here is the company which is on the verge of insolvency. So second round of discussion went, and they said, we'll help you come out of this insolvency. Don't file for insolvency. We will buy this technology for you, but you be with us for 3 years to understand how to implement this technology, because we are trying to introduce a similar kind of antibiotic in the market. And instead of working, we'll try to take this patent and work upon it. So the both of them agreed. And a mutual benefit agreement was agreed between Pliva and Pfizer in such a way that Pfizer had not to wait for 3 years to launch a new antibiotic. They launched this antibiotic and it became very successful. Today also, that antibiotic is having $1 billion sales only in USA for Pfizer. And that patent was, and that product was azithromycin. Absolutely a successful story of a synergy of IPR. Now, Pfizer was a well-managed company, so there was nothing great about them. They did a business strategy. But what happened to Pliva is very important in this. What happened to Pliva? Pliva is something that what happened is they were on the verge of insolvency. Today, Pliva is one of the biggest R&D companies in East Europe. They didn't wound up. They survived and became one of the most beautiful and most successful R&D company in East Europe. That's the synergy. That's the story. That is where the commercial application comes. That is where the documentation comes. That is where the commercialization and everything comes of IPR. The next story which I want to take is the Kodak disaster story. This is a very famous story. And in IPR world, we call it as Kodak disaster story. There were some 4 engineers who were working in Kodak. In olden days, the camera technology was that you click a photo, then you develop it, process it, and you get next day evening. You don't get immediately the photograph. Now everything is digital. That's a different story today. But in those days, it was like this. So 4 engineers studied a technology in Kodak and they said that we have something called instant camera, where you click the photograph and in 45 minutes, you'll get a photograph. The processing, everything will happen inside the machine in some time. It will not take 1.5 days. Kodak rejected this. He said this will not work because this paper quality may not good. Then they had thousands of reasons to refuse it. They said refuse it. They said this is not going to work. So these 4 engineers become very sad. So they came out of Kodak, they left that and they started a small company, which was a startup in those days. And they launched this technology and the product became very successful. Product became very successful in instant camera technology. And they were absolutely doing very well. But at the same time, Kodak also started selling it. Kodak also started manufacturing it. Said what these guys are going to do. They were our employees. How can they go against us? Kodak had absolutely a huge amount of arrogance and huge amount of ego. He said, how can they do this? Though those 4 engineers have not taken any resources of Kodak to develop this technology. They have not done that. Yeah. But these 4 people then become very sad that what do we do? So one of them said that, see, we have to, I don't know whether we'll survive or not. But in any case, if we don't want to survive, let's fight and survive. Let's not be cowards. Let's not be absolutely nincompoops. Let's fight. If it is Kodak, so what happens? As such, we are going to lose everything today or tomorrow. So they filed an infringement case against Kodak in 14 different countries. Those 4 guys have risked everything about their life. All the saving has gone in the dispute and in litigation. They had nothing to survive. But they had a ray of hope that something may good happen. And it happened. They won the case in all the 14 countries for patent infringement. And Kodak was made to pay them more than $120 million as damages for patent infringement. And that's not only the story. The story goes more further. All the courts said that whatever cameras you have sold during this dispute, you call back that and pay those family, and that amount should also go to that company because that technology belonged to him. And that was the biggest problem. And that is what actually made a huge losses for Kodak. And Kodak is out of camera business. Now Kodak is out of camera business. Now that's what it is. The issue is what I want to make a point with Kodak is There's always also a good governance and corporate governance issue even in IPR. Your company or your board of directors should understand that respect somebody's IPR. If you don't respect somebody's IPR, you may have to pay very badly as Kodak paid it. So that is all, friends, about the IPR, what I could share in whatever time I have given it. Just to conclude, I would say that in today's knowledge economy, strong IPR system can help economies on the path of growth and prosperity. As Joseph Scumter, one of the most celebrated economists, says, profit is a return on successful innovation. Let's innovate for ourselves also as company secretaries and do something great. Thank you very much, Surbiji. Thank you very much for giving me this opportunity. And thank you to all the participants for giving me patience hearing. Thank you.
Sir, indeed, it's a very, very insightful session. And before placing the formal vote of thanks, I would like to take some of the questions from the members. Most of the questions have already been answered by you through these slides, through your session. But there are some questions, so if you permit, so I can take those questions.
Please. It will be my pleasure. Don't worry.
So one question we have is, can we use copyright logo on the website of the company without registering the content?
Nani, I didn't get this question. Can you repeat it?
Can we use copyright logo on website of a company without registering the content?
No, content and the logo are two different kind of IPR. Logo, you can trademark and also do the copyright, provided the logo is an artistic work. So there is a logo and there is an artistic work also involved in that logo. So what you would need to do is you need to first register as trademark or apply for trademark. Then you apply to trademark office for no objection that we want to register this logo as a copyright also. The trademark office will give you an NOC that no such logo is registered as artistic work in this office. Once that NOC comes, you can register that as a copyright. And the content is a different kind of copyright that comes in literary work. Is it clear? Or still not clear?
Sir, I think it's clear from
No, but I'll tell you once. It's very simple. Suppose there is a logo called, say, हमने देखा था ना Nike just do it. तो वो लोगो का एक आर्टिस्टिक वर्क भी है, करेक्ट? सो जो अगर आर्टिस्टिक वर्क है तो वो आर्टिस्टिक वर्क पहले तो आई एम अप्लाई फॉर ट्रेडमार्क एंड फॉर इफ आई वांट टू वर्क रजिस्टर दैट आर्टिस्टिक वर्क एज कॉपीराइट I have to apply for trademark for an NOC. Then no such artistic work is registered with you, and I want to go for copyright registration. Copyright registrar will ask for such NOC from trademark, and then you go for copyright registration. You do the copyright registration, and that logo you can use it on a website as a trademark and a copyrighted logo both. That is one part of it. The content is a different kind of IPR on your website. That content may be protected as literary work as a separate copyright. Clear? Yeah.
So another question is, how can we see the copyright applied by a third party for objecting the said copyright?
No, there is no process of opposition in copyright. It is all the copyright office decides whether there is a conflicting thing or not. Yeah.
So whether without getting the registration done under copyright, can the symbol C be used for proprietary PPTs?
I'll tell you what it is. Copyright registration is not compulsory anywhere. See, first of all, the Berne Convention, which governs copyright, has a different unique provision that registration process is only there in 3 countries all over the world. One is US, one is Philippines, and one is India. It's not compulsory. But how would you prove that you are the first to create copyright? So that is why people go for copyright registration. And here also, you write C, such and such person, 2004-24, all right reserved. That's how you claim copyright. You don't need to register for it. But if you apply for registration, then you are allowed to write R, circle, then your name, 2024, all right reserved. So that's the difference. So copyright registration is not compulsory. But when it comes to evidential value, you should be able to prove that you were first to create this.
Yeah. A list of song lyrics in a book can be copyrighted under one application, or a separate application is required to file for each song lyrics.
If it is written by the same author, let there be one book, compilation of one book. Like there are people who are selling it. Abhi aata hai Facebook pe. कोई बुक वाला बेचता है शायर लुधियानी की गजल्स, मिर्जा गालिब की गजल्स, तो वो एक ही बुक होती है, एक ही ऑथर का एक ही है. अगर डिफरेंट डिफरेंट ऑथर का है तो इट विल बिकम डिफिकल्ट एंड लिटिल कॉम्प्लेक्स हो जाएगा.
Sir, in such case, it's my question that there are 10 songs in a book and they've copyrighted it as a book. And the person who have copyrighted it want to sell one of the song to another person. So for that, they need a special application or what? How that will work?
That's copyright. That's a collective right of copyright. How it works is there are 10 people who wrote some lyrics and you have compiled it in one book and you have sold it. Did you take permission of those 10 people to do it? Do you have the consent of the 10 people to put it in the form of a book? That's the first question. If you have consent, you have paid them their rights. Absolutely. You have bought that, then an assignment. Or it is only the royalty you are paying it, then absolutely that book, they are entitled for some kind of remuneration in form of a royalty also. Now, if you want to sell this one of the compilation, you cannot sell it directly because there is something called a moral rights of a copyright holder or moral rights of the creator. So you have to take his permission. If he says that you sell it, you can sell it, but you will have to give him his consideration also.
Okay.
There is something called performers as society. T-series works only this version model. That whatever songs you are listening in hotel, अगर आप 5 स्टार होटल में खाना खाने जाते हो तो गाना बजता है, उसके पैसे भी आप भरते हो, होटल नहीं भरता है.
Yes, sir.
There is a copyright in that. That's something which is governed by performers society. There are copyright society who governs this type of business models. They govern and run that business model, which is called as collective copyrights.
Okay.
Sir, can I have a cup of coffee?
Oh, yeah. Sure, sir, sure.
Thank you.
Only 2 questions are left, so I'm just going to take those 2 questions.
No problem. Tell me.
So one trademark is registered, a company have registered one trademark first, and the same mark is now being used by another company, mentioning that that similar trademark had been applied in 2009 but got abandoned. So can that company send them infringement notice?
If you are registered and if you are the user before 2009, you have got a better right. Yeah, you have got a better right. But if you are a user after 2009, you need to be careful.
Okay.
Even if your trademark is registered in say 2020, but you are user since 2012 or 15, and he is using since 2009, he does not have a registered trademark, but still he has a better right. If you can prove that he is using it since 2009, then you will not have any rights against him.
Okay.
Yeah.
And this will be the last question for today's session. How to apply for well-known trademark? And can anyone apply for a well-known trademark, or is there any particular criteria to be satisfied?
Yes. Section 11, I think subsection 10 or 11 gives the parameters for well-known mark. There are parameters that you should be existing for minimum 10 years. You should have 1, 2, 3, 4, 5, 6. There are requirements. And there is a separate cell in trademark office called well-known trademarks act. You apply that, they have their requirements. There is a system, there's a format to apply that. You apply with all the submissions and proofs and evidences. Then there is a committee which decide whether this should be given a status of a well-known trademark or not. That if the committee decides in your favor, your mark will be registered as a well-known mark. There's a process for that.
So, sir, as we come to the close of this insightful and engaging webinar on intellectual property rights, it's my honor and privilege to deliver the vote of thanks on the behalf of ICSI.
Yeah.
And I would like to extend our heartfelt gratitude to our distinguished speaker, CS Nayan Rahul, who have graciously shared his vast knowledge and expertise with us today. So your insightful presentation and thought-provoking discussions on the topic significantly enriched the understanding of our members and the complexities and nuances involved in IPR. And I would also like to express my sincere appreciation to all the participants, to all the members who joined us today. Your engagement, questions, enthusiasm have made this webinar truly, truly interactive and impactful. So definitely this session is going to be like having a life lasting impact on the members, because whatever we have learned in the area of IPR is truly going to enrich our experience in it. Thank you so much, sir.
Thank you so much. Thank you so much. And thank you, Surbi, very much, because you have taken all the pain to call me, coordinate with me, and your special thank to you for all the efforts you have taken. Thank you so much.
Thank you so much, sir. Thank you.